The Senzo Meyiwa murder trial resumed in the Pretoria High Court this week with explosive new evidence. The court heard how an affidavit by lead investigator Brigadier Bongani Gininda revealed that two of the accused had implicated Meyiwa's girlfriend at the time, Khumalo, as the mastermind who ordered the hit on the former Bafana Bafana captain. Now, these revelations emerged during the trial within a trial to determine whether the suspects who made confession statements did so under duress. Let's discuss these developments in the Senzo Meyiwa trial with legal analyst Melusi Xulu, who joins us now. Melusi, very good morning to you. Pardon me. Thank you so much for joining us. I mean, the focus really, besides the explosive details that we heard, the confession statements, really a lot of questions asked about there, just to determine the processes that took place. How significant was the week's proceedings, especially looking at how the trial within a trial has now strayed slightly?
Good morning, Paul, and to the viewers at home. Can you just please repeat the last part, sorry?
Yeah, just the significance of the confession statements.
Sorry?
The significance of the confession, I mean, that in itself was the focal point as we listened to proceedings this week.
Okay, apologies for this. I'm just struggling with the sound. But I think the significance of the revelation of this week is just that it puts another twist in this case, and it makes it interesting for us to ask a question if the two accused are implicating Khumalo as the mastermind, in inverted commas, as it was heard in court. There's a question that needs to be asked why she hasn't been arrested yet. Obviously, the police will say there's not much evidence, or if there is, they will say they took the matter to NPA or the Director of Public Prosecutions to decide on the matter, and they decided not to arrest Khumalo. So it just makes it very odd, because for every conspiracy to murder, there's a mastermind, and if there is evidence, she should have been arrested. And at this point, the matter has already started. It's a trial in a trial. So if the state feels that this evidence is enough, and if this accused, and I'm saying if they are convicted of statements, it obviously means that there has to be a case that we have to be open against Khumalo. So that is the position that needs to be addressed later on. So it's a very interesting twist of events, but I think the ball is in the courts of the NPA to decide going from this point onwards.
Do you think it was perhaps some sort of a strategy to only unveil this information at this point, and also the considerations that needed to be made? I mean, the lead investigator's statement speaks to how he tried to get this matter to Shamila Batoyi's office, and still that did not result in Khumalo being part of the men who stand accused.
I think with the defense, it's something that they would have wanted to be shown in the public, that the state is actually not approaching the matter in a fair manner if there's a mastermind and the 5 accused are arrested, but there's no mastermind. So they might be wanting the public to be alerted to the fact that there is evidence, possibly that Khumalo should have been arrested, and then it puts a stain on the state's case. Now, the state has the following challenges. Number one, there's a 375 of 19 dockets. I know we've spoken about it with you a couple of times, where the people who were in the house, it was stated that they should have been arrested, and that would have been for obstruction of justice. Remember, there is also allegedly a lady who was a neighbor, Maggie Peary, who came and cleaned the scene. So it just puts suspicions on really what is happening in this case. Now, the fact that there's an allegation that Khumalo is involved allegedly in this matter, it then puts questions as to what is really happening in the state's case. If you give me a second, I will take you back to Mr. Mbasa, who was arrested because he was pointed out by the mother of Khumalo. I think whether it was an ID parrot or an identity kit, only to find out that actually he's a neighbor, they know him, and they could have they couldn't have just said, the person who's our neighbor is the one who was involved in this case. It was very strange in the beginning. So, there's a lot of questions in this case. One would have thought maybe if the state was not under pressure, they should have not have started the case to begin with until they really know what they are doing with this case. I'm even seeing, and no pun intended here, in isiZulu we say, it's like the case or the state was starting this case just to no pun intended. So I really think if we really look at what is happening here, there's a lot of questions, and this should not be something that the state should do is criminal trial on. They should have just waited until they've got the right, even if it takes 15 years. We've heard of cold cases that are done 20, 30 years later. But at least when a cold case is started, it should have all the evidence in place. Not guesswork, not suspicious, and not a situation where some people who are alleged to be masterminds are not arrested. It doesn't put the NPA or the police in a good light, so to speak.
Yeah. So as we listen to the proceedings and grapple with some of the questions and really trying to link the pieces together, at what point will the court be at liberty now to institute charges against Kelly Khumalo?
Okay, I think as much as there are, explosive revelations, I think we must calm our minds down and remember at what stage are we in right now?
Yeah.
We are still doing a trial within a trial, and we are still testing the confessions made by Mr. Smeyiwa, accused number 1, and Senzo, accused number 2, amongst other things. So we have to wait until that has been done thoroughly. And I remember talking to someone and said, it's possible that the trial will even go to April or May, because there's still Mr. Mjiyako who has to come and explain his side of the story to say how the confession was made, and if accused number 2 is saying he no longer wanted him to be an attorney because he wanted him to plead guilty and so forth. So there's still that part to be done. So I'm seeing this case going beyond April, still doing the trial in the trial. So once the judge says these statements or confessions were made in a proper manner and they were not made under duress, then we've got to get to the trial. But whilst the trial is happening, I do not see Kelly joining this case. Rather, the case will be finalized. And if these accused are convicted solely, amongst other things, based on the confessions, then that charge has to be brought against Kelly Khumalo. But if not, if the court decides that this evidence is not enough, obviously they will go back to the people who are in the house. Remember, Kelly Khumalo is potentially one of the witnesses. So there's a point where she can come as a witness. There's a possibility where she can also come as an accused on 375 of 19. There's also a possibility where she can come as an accused now as a mastermind if it goes according to the scenario that I just explained, where she'll be arrested for obviously being a mastermind for the death of Senzo Meyiwa. But it's still early. Let's not be emotional. Let's wait for the evidence. Everything must be pointed out by the evidence. Because as much as you like Kelly Khumalo, you don't like Kelly Khumalo, or you don't like the 5 accused, just remember that everyone has a right to be presumed innocent until proven guilty.
Yeah.
So let's see the evidence.
Absolutely. Speaking of evidence, I mean, we saw this week the request for videos to be played, and questions were asked by the judge where these videos came from, and one spoke of how they were accessed on social media, and then the judge said, how can you expect me to watch and view evidence from a cell phone like I'm a member of a social club? What sort of processes are needed to present such evidence and showcase it to the court?
Yeah. One of the cases I usually quote when I'm dealing with issues of video evidence in court is a case of Ramogabe. I think it's a 1987 case. I'm not too sure about the year. But in that case, there was a principle that was laid down. It was stated that for a video to be admissible, first of all, it must be original, it must be authentic, and it must have not been tampered with. And which means if you want to show us a video, we must see where the source comes from. It must be original. So when Advocate Ngomezulu said it's from a TikTok, possibly the judge may not be reluctant to have that bank played from his cell phone because it must be properly obtained in a proper manner. So what I'm thinking is, because this particular issue was dealt with in court and it was recorded live by one of the media houses, I think what the defense should do is to ask those media houses or one of the media houses to just give them that video and probably state where it comes from, how it was recorded. That will convince the judge that, okay, this video is obtained in a proper manner, it's original, it's authentic, has not been tampered. Then it can be played out as it was, as we heard the records yesterday. I think that is what the judge wants. It just doesn't want the advocate to just come with his cell phone and say, my lord, this is the video I was talking about. He wants it to be done properly. It's the way evidence should be done when it comes to video.
Yeah, absolutely. Thank you so much for weighing in on this discussion. Of course, legal analyst Melusi Xulu helping us make sense of the proceedings in the Senzo Meyiwa murder trial this week.